Good morning, esteemed judges and respected speakers, and a warm welcome to the sixth edition of the virtual moot court competition. I am the court marshal for this session. Please note that this meeting is being recorded for the purpose of the moot court competition, so all the participants are required to keep their cameras on throughout the proceedings. If you experience any technical difficulties, please communicate them promptly via the chat box. We are honored to have a distinguished judge present today, whom I will now introduce. Ms. Tejasvi Reddy graduated from ILS Law College, Pune, has 10 plus years of experience in the insurance and legal domain at Tata AIG. Her core expertise lies in the assessment and negotiation of legal ability across high exposure segments, along with coverage advisory and settlement of complex liability claims across varied industry sectors. She manages key financial liability portfolios, including directors and officers liability, professional indemnity, employment practices liability, venture capital protection, cyber risk, and public offering of securities. Her role involves precise legal interpretation, analytical decision making, and strategic negotiation, in close collaboration with cross border legal experts and forensic investigators to drive effective claims and balanced resolutions. May I kindly have your permission to proceed with outlining the rules for the round?
Yes, please. Yeah.
Each speaker will have 15 minutes to present their arguments with an extension possible at the judge's discretion. In case of internet disruptions, a maximum of 5-minute extension may be granted. The structure of the proceedings will be as follows. First and second speakers of the petitioners will present their cases, followed by first and second speakers of the respondents. There will be a reply by one petitioner speaker and a reply to that as permitted by the judge. Please ensure a stable internet connection and that the cameras remain on throughout the rounds for all the speakers and the participants. Any judgments or documents can be shared on screen only with prior permission. Before we begin, Court Martial will strictly track the time allotted to each speaker to ensure smooth conduct. Thank you for your time and dedication, and speakers for your preparation. With your permission, we may now begin the session.
Sure, yes.
May it please this honorable court. The council seeks permission to proceed with the submission.
Yes.
The council further seeks permission to address this honorable bench collectively as your leadership.
Sure, yes. You may proceed.
I appear as the counsel for the appellant ABC Bank, and with your leadership's permission, I shall be addressing issue 1 and 2 and the rebuttals for a total of 15 minutes, and my co-counsel shall address the remaining two subject matters thereafter. The respondent, corporate debtor, avails substantial financial facilities from the appellant bank, ABC Bank, only to fall into persistent and unapologetic default, resulting in the account being classified as a non-performing asset as early as in April 2014. For years thereafter, despite repeated reminders, restructuring avenues, and multiple OTS proposals between 2017 and 2022, the respondent neither repaid a single rupee nor disputed its liability. The appellant's first Section 7 application was filed in 2020 and was dismissed solely due to the temporary COVID-19 suspension under Section 10A of Insolvency and Bankruptcy Code. Seeking genuine adjudication, the appellant filed a second application in 2024, this time correctly relying on the 2014 NPA and supporting it with unequivocal banking records and written acknowledgement. Yet, both the NCLT and NCLAT rejected it on misplaced grounds of res judicata and limitation, overlooking the reality of the continuing and admitted default. It is the miscarriage of justice and the denial of rightful adjudication.
Counsel, if I may ask,
Yes,
so is the first and the second application is based on the same cause of action?
yes.
So I just can you clarify then why is it that first it was mentioned as 1st May 2020 and later on in the second one it was modified it to 1st April 2014, I believe.
Your leadership, the first date of default was unfortunately during the uh, COVID-19 suspension period, which was later changed into the NPA date of 2014, April 2014, when the loan account was actually declared as a non-performing asset. It was merely a clerical error on the part of the appellant, and it has been changed in the subsequent application. However, it was rejected on the basis of res judicata limitation. It was merely a clerical error on the part of the date of default. If your leadership permit, I shall proceed with the first issue.
Sure, yes.
The first issue is whether the second Section 7 application is barred by law. Your leadership, the respondent paints a picture of impropriety, arguing that the second application is barred. But the law, the precedents, and indeed the very soul of insolvency and bankruptcy code tells us a very different story. The council submits your leadership that the second application is not only maintainable, but it is mandated by justice, supported by statutes, and compelled by precedents. The first and fundamental point is that the first application was never adjudicated on the basis of merits. It was dismissed solely because Section 10A, introduced during the pandemic, temporarily barred filings of default occurring during a particular protected period, that is the COVID-19 period. The NCLT did not test whether the debt existed, whether a default occurred, or whether the respondent had honored its financial commitments. It was purely a technical rejection. And your leadership, the Supreme Court has made it abundantly clear that a technical dismissal solely based on the technicalities and not the merits of the case can never trigger res judicata. In Canara Bank versus NG Subaraya Shetty, the court held that where the decision has not been examined on the basis of merits or had disregarded a statutory mandate, the bar of res judicata cannot apply. Your leadership, this case is a textbook example of this very principle. A dismissal under Section 10A is not finding a liability, it is merely a statutory pause. To allow a provisional dismissal to forever bar the creditor would turn IBC into a procedural labyrinth rather than a swift mechanism that Parliament intended. Moreover, your leadership, the statute itself is crystal clear. Section 7, subsection 1 of IBC, Insolvency and Bankruptcy Code, tells us that a financial creditor may file an application upon the occurrence of a default. Not once does the code restrict the number of filings, not once does it bar a second filing after curing the defects, and not once does it elevate technicality over substantive justice. The Supreme Court in Swiss Ribbons versus Union of India characterized that IBC is a beneficial legislation, one that must be interpreted in a manner that advances resolution and not obstruction. The court declared that IBC is not concerned with punishing the creditors or rewarding delays, but with reviving viable businesses and balancing economic interests. To bar a second application would punish the creditor for an earlier technicality, a result that the IBC does not and cannot tolerate. Your Ladyship, this respondent's arguments further crumble when we consider the limitation. The entire factual record is a continuous tapestry of acknowledgement worn by the respondent's own hands. If I could uh, uh, get the leadership's attention to the page 2 and 3 of the moot proposal, we can see the repeated OTS proposals by the corporate debtor. From 2017 to 2022, the corporate debtor repeatedly sought restructuring and repeatedly requested for OTS proposal, affirming the existence of a liability, out of which not even a single penny has been repaid. As the court held in Dina Bank versus C. Shivakumar Reddy, such OTS proposals and written acknowledgement under Section 17 or 18 of the Limitation Act there extend the limitation afresh each time. Thus, the second application is not only legally maintainable, it is well within the statutory limitation backed by the debtor's own admission. Finally, your leadership, the Supreme Court in an asset reconstruction company versus Tulip Star Hotels, reminded us that IBC must be interpreted purposefully and not pedantically. The court held that IBC cannot be defeated on hyper-technical grounds when the intent of the statute is the revival of distressed asset. To reject a second application would do precisely what the Supreme Court warns us against, would turn IBC into a procedural weapon rather than remedial tool. It would reward the debtor for a delay and penalize the creditor for compliance. Above all, it would extinguish substantive rights based solely on technicality. Your Ladyship, the second application under Section 7 of IBC 2016 is legally maintainable, arising from continuing an unequivocal acknowledged default, well within limitation, and firmly aligned with the court's paramount objective of resolution and revival over procedural formalities. With your Ladyship's permission, the Council would like to move to the second issue of the case.
So, counsel, so can you please clarify? So, just in this case, if this is allowed, so don't you think there will be misuse of any time the default date can be changed, stating it's a clerical error, or when the default has been happening since 2014? So why was in the first application the date was not correct mentioned correctly? It was, which means that in between there was no default, or was there continuous default? What is the case?
Your Ladyship, there has been continuous requests from the corporate debtor, from the respondent, that for a notice, that is one-time settlement proposals were happening. However, throughout the period that is between 2014 and 2022, continuous default has been happening. And there has been a time where the appellant has agreed to a notice proposal and given the creditor a specific amount of time. Even during that period, the respondent failed to repay the debt. Moreover, about the question of misuse of this clerical error, your ladyship, the IBC's main, the insolvency bankruptcy court's main objective is to find out whether a default has occurred, not that the if the date of the default is correct or not. It is a mere clerical error, and it has costed the.
So, yeah, counsel, you tell me what is the legal basis where you are allowed to change the date from one to other, and you are saying it's the same cause of action. And if it's the same cause of action, same parties, then the principle of res judicata applies, right?
Yes, Your Lordship, in leadership, in normal scenarios, yes. However, uh, as I've earlier mentioned, the res judicata cannot be applied when uh, the case was dismissed solely on technicalities. Here, it was merely a technical error. The court did not
So
delve
I'm
into.
saying that technical error, what is the legal basis that allowed you to change the date? Was there any basis? Or you just
Uh,
thought that it's an error, so I can just file a second application? And if the first application was dismissed basis the limitation, the second one will be allowed once you change the date? Or is it actually a clerical error?
it
Or
was, it
because
was,
it was
yeah, yes, Your
affected
Lordship.
because of the limitation is why you changed the date?
Your Ladyship, mentioning the date of default in Section 7 is directly not mandatory, allowing correction or amendment if in the application demonstrating default debt and limitation compliance even post pleadings.
So it is allowed. So that's what I'm asking. So there is a legal basis for your correction in the second application.
Yes, Your Ladyship,
Okay.
there is a mere correction of the date of default. The entire concept of whether the default has happened or not has still not been tried upon in the court.
Okay.
Your leadership, may I move to the second issue?
Yes, yes, please. You may. Yeah.
The second issue is whether the mentioning of the date of default is mandatory under IBC. Your Ladyship, it is respectfully submitted that while the date of default is an important procedural disclosure, an error in that date cannot defeat an otherwise valid application, provided that the factum of default stands independently proved by documentary evidence. Section 7, subsection 3, clause A requires the creditors to furnish records of default. Rule 4 of the Insolvency and Bankruptcy Application to Adjudicating Authority of 2016 mandates the attachment of Form 1 and supporting documents. Yes, the date of default forms a part of this evidentiary package. But your ladyship, the Supreme Court has repeatedly held that the object of IBC is not to demand perfect paperwork, it is to ascertain whether a default occurred or not. In Innovative Industries Limited versus ICICI Bank, the Supreme Court emphasized that NCLT must be satisfied that a default has occurred on the basis of the record submitted. The emphasis is on default and not clerical accuracy of the date mentioned.
Can you
This,
direct me to this precedent?
yes, Your Ladyship. With your permission, may my researcher share the screen?
Yes, please. Oh, okay.
Your, your Ladyship, if you are satisfied with our arguments, may I proceed to the next?
Yes, please, you may please proceed.
Yes. Much obliged, Your Ladyship. This position was reaffirmed emphatically in E.S. Krishnamurthy and others versus Bharat High-Tech Builders, where the court held that the adjudicating authority cannot refuse admission on technical grounds once default is established. Similarly, in M. Suresh Kumar Reddy versus Canara Bank, the Supreme Court held that once the default is shown, the NCLT has no discretion to reject the application. It cannot nitpick technical defects, it cannot elevate form over substance, and it cannot deny admission for curable fact within 7 days. Your Ladyship, what then is law? The law is that default must be proved, not that the application must be flawless. The law is that justice must be done and not the procedure must triumph. The law is that commercial realities matter and not clerical errors. In the present case, the corrected date reflects the true default, that is the NPA, non-performing asset, of 2014, supported by bank records, loan documents, and years worth of written acknowledgement. The respondents attempt to inflate a clerical error into a huge allegation of manipulation is not a legal argument. My lordship, if you may permit, may you grant an extension of 2 more minutes? I am just winding up the uh, arguments and
Sure,
handing
sure.
over the mic to
So,
you.
Counsel, I just have one doubt since you have been, highlighting the intent of the statute, IBS, right? So, just tell me in simple terms of how you say that this focus on whether the statute focuses on resolution or recovery, and how does your case align with that objective? Because you have been highlighting the intent of the statute, so I would like to hear.
Your Lordship, the Insolvency and Bankruptcy Code of 2016 is a remedial framework which is repeatedly affirmed. It is more focused on reviving the distressed companies. It is more delving into the topic of the insolvency processes and how it can be carried on effectively without damaging any viable businesses. Our, during the entire time from 2016 to now, IBC has always taken a stance to uh, help viable businesses, which can also be seen in Section 10A, which barred application during the corrected period. And moreover, this case aligns Dina Bank versus C. Shivkumar Reddy, as I've earlier mentioned. It aligns with ABC Bank's Section 7 petition. And in Dina Bank versus C. Shivkumar Reddy itself, we can see that the Supreme Court itself says that IBC is a reviving tool, and it It is a reviving tool for both the corporate debtors and the financial creditors. And during the case present in hand, we can see that a, a loan of 500 crores has not been repaid over a period of 10 years. So, your lordship, your leadership, you yourself can understand how this is putting a financial burden on the financial creditor, and it is letting loose uh, the respondent. May I continue with my
Yes,
submissions?
yes, yes, please. You may continue.
Your leadership, the Supreme Court in Swiss Ribbons reminded us that IBC is a flexible, pragmatic, commercially conscious legislation, and to reject an application on the basis of a very curable fact in the date would betray the entire spirit. Your leadership, the submissions on issue 1 and 2 reveal that the second application is completely lawful and necessary for the respondent. Continuing the default cannot be concealed behind technical lapses or erroneous bars of res judicata. To deny admission now would let the procedure overpower the substance of the entire matter. As my co-counsel will show under issue 3 and 4, the evidentiary record and statutory framework uniformly support admission. Therefore, in the interest of justice, fairness, and true purpose of IBC, the counsel for the appellant humbly submits that the appeal must be allowed.
Okay.
Counsel seeks permission to address the bench as your ladyship.
Can you please be a bit louder? I'm unable to hear you.
Counsel seeks permission to address the bench as your ladyship.
Yes, please. You may proceed. Yeah.
Much obliged. Starting with the third issue, your ladyship. Default under Section 7 is a substantive factual concept and not mechanically tied to the NPA date. Section 7 requires the adjudicating authority to be satisfied that a financial debt is due and a default has occurred. This necessarily involves an assessment of an entire course of dealings, not just the accounting classification of NPA. The NCLT in Dina Bank versus C. Shivakumar Reddy has recognized that the date of default can be amended and aligned with the evidence that emerges during CIRP, emphasizing real financial default, not mere NPA entry. Subsequent conduct, such as restructuring proposals, repeated OTS offers, and written admissions of liability, demonstrates the continuing and recurring nature of default. The decision in Vijay Kumar Singhania versus Bank of Baroda and another affirms that proof of default under Section 7 is flexible and should respond to the actual financial status of the corporate debtor rather than to be confined to a single historic NPA date. Your Ladyship, the court in Innovative Industries Limited versus ICC Bank has held that default is to be established on the basis of records and the surrounding factual circumstances, including communications and persistent non payment. In Swiss Ribbons Private Limited versus Union of India, this Honorable Court clarified that the IBC is a remedial legislation intended to revive viable businesses, guided by commercial realities and fairness rather than procedural technicalities. The date of default must be interpreted in a manner that reflects ongoing financial distress and continuing breach, not as a rigid one-time event fixed to NPA classification. The facts here also shows that even after NPA on 1/4/2014, the relationship did not freeze. Negotiations continued till 2022, and OTS was sanctioned in 2020 and failed for non-compliance by the corporate debtor. This continuous chain of restructuring and acknowledgement keeps the default alive as an ongoing breach, and the operative default for Section 7 must therefore be gathered from this commercial substance of non payment, not merely from the first NPA entry. Lastly, the legislative introduction of Section 10A during the COVID-19 period. This introduction itself acknowledges that default timelines interact with the real world economic event and may be deferred, suspended, or shaped by such circumstances. This policy shows this policy choice supports the construction that default is not static in time, but fact sensitive, and it's an evolving phenomenon. Your ladyship, can I proceed with the fourth issue now?
Yes, you may. Yeah.
Much obliged. Even assuming there is some technical error in stating the date of the default, such error cannot defeat a Section 7 petition where default is proved and the application is within the limitation. Section 7, subsection 5 empowers the adjudicating authority to admit the application if satisfied that a default has occurred and that the application is complete and within the limitation. If satisfied, the phrase if satisfied indicates a discretionary evaluation of the substance. The authority is required to see whether default exists on the material place and not to reject petitions for minor procedural lapse or like clerical errors in dates. This Honorable Court and NCLAT have consistently held that minor defects and technical errors should not lead to rejection where the substantive condition of the code is fulfilled. It is, however, submitted that the judgment of the NCLAT carries no persuasive value before this Honorable Supreme Court. Nevertheless, reference to the NCLAT's reasoning may be made to underscore the principle that the procedural formalities ought not to overshadow the substantive compliance with the code. In E.S. Krishnamurthy and others versus Bharat High Tech Builders Private Limited, this court reiterated the principle from innovative industries that the jurisdiction under Section 7 is confined to examining 1. The existence of a financial debt and 2. Occurrence of default, and does not extend to denying admission on the basis of rectifiable irregularities. The court made it clear that once default is established, the application must be either admitted or rejected on the substantive ground. It cannot be held in or rejected due to minor technicalities.
So, counsel, so the application was dismissed only on technical grounds in this case, or was there no merits at all? Is that what you mean to say? So it was merely on technical error, and you're saying that NCLAT had no other findings for dismissal or rejection of this application?
Yes, your ladyship, it's like solely due to Section 10A that was introduced during the COVID-19 period.
So that was the basis?
Yes, your ladyship.
Okay, it's fine, yeah.
Your ladyship, may I proceed?
Yes, you may please continue, yeah.
Okay. In M. Suresh Kumar Reddy versus Canara Bank, this Honorable Court held categorically that once NCLT is satisfied that a default in payment has occurred, it has no discretion to refuse admission of the Section 7 application, where the statutory requirements are not fulfilled. The court emphasized that NCLT cannot go beyond the inquiry into default for the purpose of admission, and that technical irregularities in the application cannot be a ground to reject it. At most, the applicant must be given time, generally to 7 days, to cure such defect. Lastly, applied to this present case, the material on record clearly shows an undisputed financial debt, persistent and continuing default, and an application well within the prescribed period of limitation, especially in light of ongoing negotiation and acknowledgement of liability. In such a scenario, a misstated or imperfectly articulated date of default is at best a curable defect and not a jurisdictional bar. Therefore, under Issue 4, it is respectfully submitted that where default and limitation are satisfied, this Honorable Court may direct admission of Section 7 petition and cannot allow a mere technical error in the date of default to extinguish the financial creditor's substantive statutory remedy. Now the council would like to proceed with the prayer.
Yes, you may please proceed.
Much obliged. Therefore,
Sorry, yeah.
Therefore, in light of the issues raised, arguments advanced, and authorities cited, it is humbly prayed that this honorable court may be pleased to adjudge and declare to allow the present appeal and set aside the orders passed by National Company Law Tribunal and National Company Law Appellate Tribunal. Hold and declare that the application is maintainable in law and not barred by limitation, and that the date of default is determined by the fact and circumstances of each case. Direct the initiation of corporate insolvency resolution process against the corporate debtor, and or pass any order, direction, or grant relief that it may deem fit in the best interest of justice, fairness, equity, and good conscience. For this act of kindness, the appellant shall be duty bound forever, all of which is most humbly and respectfully submitted.
So the council, the case laws you have cited are there in the memos, right?
Yes, Your Ladyship.
Right, yeah. I think, yeah. Can continue, yeah. I think now maybe the respondents can start, the councils for respondents.
Yes, Your Ladyship. I shall be keeping the time myself as well, and I request them to keep the time as well. Ma'am, am I audible?
Yes, you're clear, yeah.
Okay. Good morning to one and all present here. Good morning to the bench, honorable bench, the ladyship, and the participants. Ma'am, ladyship, this is TGA 47. I am Megha Chari, speaker 1 of for the Team 47 code. I shall be addressing issues 1 and 4. My co-counsel Nanyashri will be dealing with issues 2 and 3. Your Ladyships, if I may proceed with the facts, or may I proceed with the issues directly?
You can directly proceed with the issues, yeah.
Absolutely. Much obliged, Your Ladyships. Your Ladyships, issue 1 and 4 are concerned with the issues 1 and 4 are concerned with the submission regarding that the second section 7 maintainability application post the section 10A dismissal by the NCLT and the NCLAT is impermissible in this court. And issue 4 will be dealing with the admission which would be despite the pleaded default error. Your lordships, your ladyships, the 500 loan facility that was taken by the by the debtor is being challenged in this court as the same was taken. The debtor had taken a 500 facility loan from the financial creditor in 2014. The same facility, due to some disruptions in the business, had to be taken care of, and we had committed an default. The same default is not an intentional default, but rather due to the disruption and the global breakdown, which was by the unfortunate widespread
So,
of COVID
council,
19.
if I may interrupt, I think the default has been happening since 2014, right?
Absolutely.
To use COVID-19 pandemic as a reason for the default, I think is not fair. Because I see from the facts that the default has been happening since 2014, if I'm not wrong, right?
Yes, Your
So I think in between OTs were being requested, and then there was one agreed also, but then that was also defaulted. So can you please clarify the reasons for
Yes, Your
something before 2019, the defaults before 2019?
Your ladyships, you have you have corrected me absolutely. But the pleaded date of default that was taken in the first petition by the financial creditor is deemed to be 1/5/2020. Your Ladyships, in the appellant's memo and the arguments that were submitted by the appellants, it is clearly mentioned that the OTS proposals that were mentioned do redirect the default date to the present default date that was taken in the first petition, which is 1/5/2020. It is an uncontested fact that the loan disbursement was done in 2014. However, your Ladyships, the first petition's date of default that was mentioned was 1/5/2020. It was not a clerical error, your Ladyships, but rather a, an intentional error, an intentional date that was chosen by the bank, and later it was being circumvented after the NCLT and the NCLAT had rejected their claims. Your Ladyships, I may answer your question in a threefold manner, in which the issue one shall also be covered. Your Ladyships, the sub-arguments that I'll be taking forward are mentioned in the memo in page number 7, 1.1, 1.2, and 1.3. Your Ladyships, the sub-argument 1.1 refers that the essential for a fresh cause of action to be taken forward by the financial creditor should be mentioned in the petition itself and should make a prima facie case for the honorable bench. Your Ladyships, the second section 7 petition is only maintainable if it is not statutorily barred and is limitation free, which should be founded on the genuine fresh cause and should not be repackaged for a prior claim that was made. Your Ladyships, the facts of the case clearly mention that the as opposed as mentioned by the appellants as well, that there is a 7-day window which is given for the amendments that should be made at the discretion of the bench. This 7-day window was non-utilized. It was unutilized by the petitioners in this case. Your Ladyships, the 7-day window was not utilized. Even in the appeal that was made to the NCLAT, they did not cover the amendment. They did not request for an amendment in the date. However, they directly went on to the Honorable Apex Court by dismissing the judgments that were passed by the NCLT and NCLAT to take a second petition with an altogether different date of default. Your Ladyships, it was correctly held by the NCLT and the NCLAT that the date of default that you have mentioned cannot be changed on the whims and fancies. Your Ladyships, the the identical debt of 500 crore facility, the parties and the facts are all the same. The sole change and the sole malicious change that is being done here is that the default date shifted from 1/5/2020 to 1/4/2014, which is impermissible of refoundation that is being done in this case. Your Ladyships, talking about the circumvention of the 10A bar, which is covered in the 1.2 sub-argument of in the memo page 7, the first petition was filed in 1/2/2022, which was premised on 1/5/2020 default, which fell squarely within the 10A, which the petitioners only came to be aware of when the NCLT and the NCLAT dismissed their petitions, as they had not filed for any amendments during the 7-day window period, and they had also not filed for an request in the amendment in the appeal that was made to the NCLAT as well. They only came to realize about their fault and the error, their supposed and alleged error, when they appeared before the Honorable Apex Court with a second application. Your Ladyships, here I would like to mention the para 11 and para 19 of Ramesh Kemal versus Siemens Gamesa, which is a 2021 case defined by the Apex Court itself, wherein they say that the financial creditor cannot escape the time foundation that is being given by the 10A by altering the default date post the date filing, as there is a bar that is attached to the pleaded fact, your Ladyships. Post dismissal, the post dismissal shifts, it defeats the legislative intent. The appellants had misdefined the object of IBC, which was corrected by the speaker to in the course of time, which said that it is not a debt recovery tribunal, but rather it is a rehabilitation place for the corporate debtors. Even the amendment that was brought forth by the
So, Counsel,
Union
are you
of
trying to
Bureau,
say the purpose of IBC is to protect the defaulters who will not repay the loans?
absolutely not, your Ladyships. The point that I'm trying to portray in here is that it is a rehabilitation place for the corporate debtors. It is not a time foundation. It is not a correcting factor in here. But when the government of Union of Indigo introduced the Section 10A during the COVID pandemic, it was to protect the corporate debtors who had secured and unsecured loans and had been declared as NPA. Your ladyships, the post dismissal shift, even though there is a legislative intent that was there, the defaults in the COVID window were to never trigger the CIRP in the first place. Your ladyships, moving on to the subargument 1.3, wherein I shall discuss of the res judicata, which bars the re-agitation, as correctly mentioned by your ladyship as well. Your ladyships, there is the same parties, the same debt, and the same transaction in question. Even the first dismissal on the maintainability of the merits attains the finality as per the case of Satyadhan. Your ladyships, the appellants had proposed that the res judicata was not taken in this case by them. However, it is being contended as there is no fresh cause of action that is being brought forth by the appellants in here. The OTS proposal and the restructurers do not create a new default date. Therefore, the remedy is not an appeal or a fresh petition. Rather, it is the realization that you are trying to circumvent the 10A, which is provided by the government in IBC and held by the NCLT and NCLAT as well. Your ladyships, I would like to mention para 19 of Ramdas Datta versus IDBI Bank as well, wherein it was held that the default date, when if fixed, cannot be changed arbitrarily by the whims and fancies and without a sufficient cause of action. Your ladyships, non-utilization of the 7-day window period and no request further made by the appellants during the NCLT and NCLAT proceedings clearly portray the intentional wrongdoing, that they are trying to miscarriage that they are trying to portray grave injustice when they are approaching the honorable court with malicious intentions.
So, counsel,
I
tell me, if I may interrupt, I just want you to clarify this. So,
Yes.
if the date has been submitted, either technical error or clerical error or intentional or anything, and the subsequent application filed by correcting what they believe is, default date. So, do you think just because of that change in the dates will evade them of the statutory rights and the protection under the laws? Just because the date has been, if date is the issue, right? In this context, in this case, right?
the same is
So
contested. Yes,
whatever
your ladyship.
amount has to be paid by your client, right?
Yes, your
So will that be evaded just because there has been error in the date? So what is your submission on this? Or do you think that Section 10A, right, will provide
yes.
protection for every default before and after pandemic or during pandemic? What about before pandemic then? Is 10A does not permit for CIRP then? For defaults that occurred before pandemic? Can you please clarify this?
Absolutely, your ladyships. I shall clarify this. Your ladyships, when the amendment which was brought forth by the Union of Indigo in during the pandemic, it created a window from 25th March of 2020 to 25th March of 2021. If any petition, if any date of default arose within this timeline, there can be no petition filed for the initiation of CIRP in any court whatsoever.
Correct.
Absolutely, your ladyships.
Correct.
Leaderships, even though the transpiration of the default date was there in 2014, the pleaded date of default in the first petition was taken to be 1/5/2020. Even in the appellant submission, it was said that the OTS proposals create that limitation and extend that limitation till 2022. Absolutely correct, your ladyships?
Yeah, can you please repeat? So you're
Yes.
saying
Yes,
yeah.
the appellant submitted that the OTS proposals and the restructuring facilities that were availed by the corporate debtor had extended the limitation till 2022. Right? Now, this limitation, when the appellants itself are contending that the date of default can change within these OTS proposals and structures, it can be that is the sole intention for why they took 1/5/2020. If they did not believe that the OTS proposals could extend their limitation, they would have filed it in 2014 itself when it was declared NPA. But they did not do so.
I think from the facts, it appears that the negotiations were ongoing, right, Council? So when the negotiations are ongoing, I don't think so they'll just go and file the applications. They'll try to resolve it, right?
Yes, your ladyships. And that is why, through these OTS proposals, the last date of cancellation of the OTS proposal that was made was on 1/5/2020. And this 1/5/2020 was taken as the last date of default by the financial creditor. And in 2022 of February, 1st February, they filed a petition in the NCLT. Now, when this test was done, your ladyships, the same issue shall be covered by me in issue 4 as well. The same issue shall be covered in the issue 2 by my co-counsel as well. You shall get the clarity. Please do not worry about that. Your ladyships, to answer your question regarding the limitation period and the statutory bar that was set, and even if there is an error, it can be curable. It is a curable error, is what is being asked by your ladyships. Your ladyships, issue 4 curtains on the same. Your ladyships, issue 4 says that there shall be, if there is an error, there are two ways to clear that error. The first way is you do not admit, and the second way is you admit. Now, for the admissibility of the same, it is required, it is a simple principle of law that has been held by the NCLT and NCLAT, that to, as the amendment is at the discretion, your ladyships, may I be granted 2 minutes extra for the oral arguments?
Yes, you may continue. Yeah.
Thank you, your ladyships. Your ladyships, Section 7 demands accurate default particulars. Even in Section 3, Clause 12 of the IBC, it is mentioned that the unpaid and undue remain is when the default date structures. Now, your ladyships, when you change the default date, this restructures the changes and changes the cause of the action itself that is being taken. The error scrutiny that is there, we are contending that there is a misleading and it creates a prejudice against the debtor. The discretion at the honorable bench is that an amendment may be allowed, provided that it does not prejudice the rights and liabilities of the debtor. However, your lordship, this change in default date misleads and prejudices the debtor because it is the abuse of power that is being done. We shall be extremely in grave injustice if the same is allowed, because they will be circumventing 10A if you allow this petition to go through. The limitation from actual default when the due or unpaid distinct from when the due and unpaid loan was taken, the acknowledgements were also done. Even though the acknowledgements were done, the fresh petition which was taken after dismissal invites the res judicata and the abuse scrutiny as well. Therefore, no technical defect shield can be taken by the financial creditors in the present days, because if the dates are changed, it evades Section 10A. Your lordships, there would have been no problem if it did not fall within the COVID window period. But the problem is only arising because the first petition's default date is squarely falling within the Section 10A, which is the prejudicial rejection is warranted by this, your lordship, your ladyships. I hope I was able to satisfy the query of your ladyships.
Yes, Council. Yes. I think now Speaker 2,
Yes, your
the
ladyships.
co-counsel may start.
Yes, your ladyships. Much obliged, your ladyships. Thank you so much.
Yeah.
I would be starting in 5, 4, 3, 2, 1. A very good morning to everyone present here. May it please your ladyship, should I address the bench collectively as bench and individually as your ladyship?
Sure. Yeah.
Am I? Yeah.
Yes. Yes.
Thank you so much. I appear for respondent XYZ Private Limited, counsel number 2. With your ladyship's permission, I will address issue number 2 and 3,
Yes.
which are whether mentioning the date of default in Section 7 application is mandatory, and whether the date of default can vary with circumstances or must it remain the NPA date. Under issue 2, I would be presenting my arguments in a threefold structure. Firstly, I would be proving how date of default under Form 1 and Section 7 application is mandatory and not at all directory, I would be proving how allowing creditors to shift the default date would lead to abuse of process and how it again goes against the core nature of IBC. Proceeding with issue 2 first, your ladyship, the appellant's difficulty does not arise from a mere technical lapse, as they have mentioned repeatedly. It arises from the attempt to rewrite the core facts of the case. They filed as per Section 7 application on 1st February 2022 and consciously pleaded the default date as 1st May 2020. The date fell within Section 10. Their application was hence dismissed on merits. Having failed, they now file a second Section 7 application on 1st January 2024, pleading the default date now as back to 2014. This is not correction, your ladyship. This is reinvention designed purely to evade the Section 10A bar and revive any claim already adjudicated. Hence, under issue 2 and 3, these are not merely procedural issues, they concern finality and the prevention of abuse of the IBC framework. Under issue 2, your ladyship, Rule 4, Clause 1 of the Insolvency and Bankruptcy Application to Adjudicatory Authority rules states clearly that Section 7 application shall be filed in Form 1. When we read Form 1, your ladyship, Part 4 explicitly requires the mention of date of default. Hence, date of default becomes important to determine liquidation, jurisdiction, and Section 10A applicability. This requirement is extremely mandatory. This is also further supported by precedents like Ramdas Datta versus IDBI Bank, which was also stated by my co-counsel in her speech, where the NCLAT has categorically held that once the date of default is pleaded, it becomes binding. The creditor cannot subsequently alter it. The appellant here, as mentioned by me before, pleaded the date of default as 2020 first, and only after the dismissal of their petition mentioned the date of 2014. Again, this court in Innovative Industries held that NCLT must first be satisfied that the default has occurred, and that satisfaction, your ladyship, is impossible without a consistent and a correct date. Therefore, omission or manipulation of the date is a foundational defect, not a curable irregularity, as has been categorically mentioned by the appellants throughout their speeches. Moreover, your ladyship, my next submission under this sub-issue deals with the abuse of process. When we allow the creditors in this case to shift the default date, it can also lead to multiple Section 7 petitions. Circumvention of limitation period, repression of Section 10A, which was put forth by the legislature for a certain legislative intent, avoidance of res judicata, your ladyship, and perpetual harassment of corporate debtors, of course. The appellant first relied on 2020, then after losing again, they went to 2014. This it shows that there must be.
Counsel, just tell me, just clarify this. So are you saying that there has been no default from your client?
No, not at all, your ladyship. We are not contesting the existence of default. We are merely contesting that the default date cannot be shifted on the whims and fancies of the creditors.
Oh, that's fine. So that's fine. That I understood.
Yeah.
So in the earlier argument which you made, you were trying to say that they're trying to prove that it's been defaulted and all. So before pandemic also there was a default. Do you or do you not agree that there has been default from your client to the bank?
We certainly do not dispute the existence of default. There has been default, there has been non-repayment, but we genuinely we are.
So are you saying there has been default and just because the appellant has an issue with the date in the first and the second filing, so should they be, not have any other remedy to recover? So that is it. They'll not recover the amount just because there's change in the date.
The council would be answering your query, which is a very valid query in this present matter. Under issue 3, if your ladyship could bear with me for 1
Yeah,
minute.
yes, you may please proceed. Yeah.
But to answer it prima facie at this point, your ladyship, we are not saying that they do not have any remedy. They have other remedies in form of civil recovery and DRT and other petitions. We are just saying that they cannot abuse the process of law by changing the date of default after 2 years. They filed their first petition in 2022, and then they changed the default date in 2024, your ladyship. So they cannot take all the time in the world, change the default date as per their convenience, and come to the court and ask for a remedy that is not just an abuse of process, but is also a grave injustice against the corporate debtor. If your ladyship permits, the council would directly like to move to the issue 3 to satiate all the viable questions that the bench has.
Sure, you may please.
Yes, I'm very much obliged, Your Ladyship. Under issue 3, which is whether the date of default varies with facts and circumstances, or should it be just a constant date, the council would prima facie like to argue and plead before the bench today that the default is a fixed and factual event, and it should be treated like that. It cannot be treated like a fluid date. Under this sub-issue, Your Ladyship, I would be taking the recourse of threefold arguments. Firstly, I would be proving how the financial creditor's shifting of default date reflects strategic behavior and not genuine mistake. Secondly, I would be proving how default occurs just once and not repeatedly, and it has been held by several presidential authorities. And lastly, I would be proving how OTS and acknowledgement letters only extend limitation. They do not create a new default date for the appellants to come and file a new petition for. Moving forward with my first sub-issue under this, Your Ladyship, the conduct of the financial creditor itself demonstrates why the date of default cannot be treated as elastic. Here is why. When the first Section 7 application was filed in 2022, the financial creditor consciously chose to plead 2020 as the default date. Now, despite the undisputed NPA date, which was there in 2014, which is mentioned in clarifications as well, that the 2014 is the NPA date, they chose to mention the 2020 date. Now, what we're trying to plead here is that the choice was not inadvertent. It was very deliberate. A later default date artificially compresses the period of limitation and, more importantly, enables the creditor to treat the entire accumulated liability from 2014 to 2020 as continuously subsisting and interest bearing on contractual terms, calculated unilaterally by the creditor. However, when the strategy backfired due to limitation of Section 10A, the financial creditor reversed its position and attempted to revert the date back to 2014, not out of legal consistency, but because the earlier PD 2020 date rendered the petition non-maintainable. What we're trying to plead here is, Your Ladyship, the shifting dates reveal an effort to oscillate between a later date convenient for maximizing contractual approvals, which is in the form of interest, and an earlier date convenient for evading the statutory bar under STEM. Such selective pleading underscores precisely why this court and NCLAT have insisted that the date of default is a fixed and factual point and not just a strategic choice. The Supreme Court, this honorable court, in HPCL biofuels case also reiterated that the IBC was not a debt recovery legislation. It called on creditors to curb the practice of debt recovery through IBC. Your Ladyship, moving further, their default occurs once and not repeatedly. Section 3, Clause 12, as also mentioned by my co-counsel on behalf of appellants, defines default as non-payment when it is due. Non-payment first occurred in 2014, long before 2020. Even RBI's IRAC norms also treat NPA classification at the precise point when the default becomes due, when it's crystallized. Default is not a shifting concept. The NCLAT also has repeatedly held in cases like Barak Retail Private Limited that once default crystallizes, nothing, not just OTS, no negotiations can alter it. Thus, the correct default date remains 2014 date. But they chose the latter date for the reasons that I have mentioned to suit their convenience. And what we're precisely trying to argue is, since they've chosen the latter date, they should stick with it. They do not have the convenience to just go back to the original date on their whims and fancies. OTS and acknowledgements, they merely extend limitations. They do not create any new default date. What we're trying to argue, Ladyship, in this, as you posed your question earlier to my co-counsel and to me also, that there is only one consistent default date in this present matter, which is the 2014 default date, which we are not disputing. There has been default, and the NPA date can be treated as the default date. But since the appellants have chosen the latter path of taking 2020 default date, they cannot shift the default dates just on their convenience. Now they have their other remedies in law possible, like DRT and civil recovery. But as corporate debtors, we are trying to plead before this honorable court that you may not allow the financial creditors to take advantage of their wrongs. If they wanted to change, so my co-counsel for the appellants also mentioned that the dates was just a clerical error. Had it been clerical error, as mentioned by my co-counsel as well, the 7-day period window was also there.
They could have also tried to change their application in 2022 itself, when the application was barred under tenure. But they chose to come 2 years later, and only all of this to circumvent limitation period. Hence, in a nutshell, what the Council for Respondents has tried to argue before the leadership today is that the appellant relies on series of OTS proposals and acknowledgements in the Section 18 to extend limitation. However, and relying on several judicial precedents like Tejas Khandar and Samarnath restaurants, the OTS agreement did not alter the date of default. Default during Section 10A period remained the same, which is the 2014 date. Hence, it's a textbook case of manipulation of dates. The appellants knowingly filed 2020 date as their date of default. And after it was dismissed, they went back to 2014. Therefore, default date is fixed, which is 1st April 2014, making the second Section 7 application non-maintainable. Your Ladyship, just to summarize everything that I've presented before you, and to open the floor for any questions that you might have, default never renews. It remains the same. It does not generate. There has been no new default date. It has been the same default date, and it has been consistent with the NCLT and NCLAT judgments. Moreover, the appellant is trying to attempt retrospectively modify the default date to suit its litigation strategy, which we plead before this court should be stopped. Hence, the appeal accordingly deserves to be dismissed. Your Ladyship, if you have any question with respect to the arguments of the respondent.
No, I don't have any questions. Thank you.
Okay, thank you so much. Moving forward to the prayer. In light of arguments advanced, facts represented and authorities cited, for the reasons set forth in foregoing submissions, the respondent successfully prays that this Honorable Supreme Court may be pleased to reject the Section 7 application as non-maintainable, declare that mentioning date of default in Section 7 is mandatory, absolutely, hold that the date of default in banking matters is conclusively determined by the NPA date, and lastly, direct that applications with incorrect or altered dates can be scrutinized and rejected for abuse of process. Very much obliged to Ladyship. Thank you for your time. It's an honor to argue before this court.
Thank you.
Your Ladyship, with your permission, may the counsel for the appellant move towards the rebuttals?
Yes, yeah.
Firstly, to the respondent's claims that the second application lacks fresh course of action and is barred by Section 10A or res judicata. The appellant rebut that first dismissal was purely based on technical grounds under Section 10A without any merits. Supreme Court in Canara Bank versus N.G. Subbaraya Shetty, which has already been mentioned in our previous arguments, hold that res judicata is inapplicable to such cases. Section 10A suspends filing for a specified number of period for a specified period during the COVID-19, but does not extinguish underlying liability or bar corrected subsequent application and permit filing upon default occurrence without numerical limits. Now, secondly, to the respondent's claim that the claims acknowledgement extend limitation but not default date, appellants agree on limitation extension, but note that continuous negotiations, as your leadership has already mentioned, was carrying out from 2014 to 2022, demonstrating ongoing default. There was not a static event. As per innovative industries, which has already been mentioned in our main arguments, it emphasized on the factual circumstances over rigid NPA fixation. Now, the counsel for the respondent has a final question towards the counsel for the appellant has a final question for the counsel of respondent. That is, what exactly is the intention of the corporate debtor in the default of 500 crores for nearly a decade? Despite repeated reminders and restructuring opportunities and multiple OTS proposals, what has it done? If the respondent genuinely intended to repay even a single penny, it would have been done in the 10 years. Moreover, the corporate debtor is not losing anything. Only the financial creditor who gave the corporate debtor, that is the respondent, 500 crores worth of debt, it is not a small amount, has been facing losses for 10 years. So I humbly request the counsel for the respondent to answer for the same.
Your ladyship, with your permission, the counsel for respondent asks for permission for further rebuttals.
Yes, yeah.
I shall only take a minute to answer the rebuttals posed by my co-counsel. It's not that the corporate debtor or anybody else in debt, for a matter of fact, enjoys being in debt. It was that we were facing business difficulties and there were circumstances beyond our control that we could not pay their debt. However, it just does not justify them changing just playing around with the IDC framework and the position of law in general by changing the date of default on their whims and fancies, which is precisely what we are opposing. As respondents, we have not refused to pay their debt. And as mentioned by my co-counsel and by me throughout our speeches, we are consistently opening the door for any alternate remedy that they have, and they have several alternate remedies in law. We are just saying in the present case, they are coming to the court with the wrong hands. And you cannot knock the doors of justice with when your hands are yourself dirty. Hence, the present appeal be dismissed and the intention of the corporate debtor be considered likewise. Thank you very much. Very obliged.
So appellants, counsels for appellants, do you have any other questions or?
No, Your Ladyship. That's all.
Okay.
Thank you, Judge, for your invaluable time, keen attention, and expert adjudication throughout this round of the 6th virtual moot court competition. Your dedication ensures the highest standards of moot court proceedings. The floor is now yours for any questions or deliberations.
So thank you all. It's really good to see all women lawyers. And I can see all of you have really bright future. I have heard all of your arguments. All of you have done well. And I'll be conveying the final decision to Manav. So, but for you guys, you have all done equally well, and it's really difficult. It's going to be very difficult for me to inform. Just like Manav said, please understand that it's about winning and learning. There's no losing in this. It's all experience, and you're all good. So I wish you all the best. And Sena, I think the session is done.